Good afternoon, dear colleagues and dear participants. As Associate Dean of FGV DIREITO São Paulo, I'd like to say that it's a great pleasure to have you all here to start the fourth and last week of the first University of Chicago Law School, Fundação Getúlio Vargas, Direito Rio and São Paulo, in this forum in Law and Economics in Brazil. This online first forum, Chicago FGV, fulfills, at least in part, the purpose of taking forward the joint initiative of our law schools to organize annual meetings on law and economics in Brazil. We believe this online forum is a good sample of what we expect to do face-to-face next year in Rio and São Paulo. I'd like to take this opportunity to thank my colleagues, Omri Ben-Shahar and Todd Henderson from the University of Chicago Law School, and Rodrigo Viana and Antonio Maristrello Porto from FGV Direito Rio. I'm grateful for all their energy and enthusiasm to organize this venture. Our special thanks to the Chicago and FGV teams that spare no effort to make this event happen in the best possible way. Before we start, I'd like to remind you that all statements expressed by Fundação Getúlio Vargas in our online events and broadcasts exclusively represent their opinions and not necessarily FGV institutional position. We also reiterate that everyone present here agreed to participate in this event of their own free will, and they consented to be recorded in these broadcasts, which will be posted later at FGV and Chicago University official channels. I also would like to remind you that this is possible to send comments or questions to a Slido link from the YouTube description. Please feel free to do so. This week, we are debating the economic analysis of consumer contracts. Professor Omri Ben-Shahar today and Professor Luciano Tim this Thursday will conduct this discussion. This afternoon, we'll have a lecture by Professor Omri Ben-Shahar, our dear colleague from the University of Chicago Law School. Professor Omri Ben-Shahar is the Leo and Eileen Hetzel Professor of Law at the University of Chicago Law School and the current director of the Cozy Sandler Institute for Law and Economics. He's currently serving as a reporter for the American Law Institute's restatement of the law consumer contracts. He writes and teaches in areas of contract law, consumer law, insurance law, trademark law, food law, and law and economics. He also writes a regular column for Forbes. Our special thanks, Omri, for all collaboration in this joint initiative. Please, we have the digital floor. Thank you all again.
Can you hear me? Okay. For giving me this podium to talk to the audience today. I also would like to thank three people who are kind of responsible bringing us Chicago to Brazil. Orlando Silva, Luciano Tim, and Eric Navarro, who participated in programs that we offered in Chicago over the past decade and who created friendship and partnership with me and the faculty in Chicago and invited us to come to Brazil, and what culminated in this 4-week event, and this is the last week of it. With no further ado, I'd like to start my lecture. I will speak for about an hour, maybe a little bit more, about the economic analysis of consumer contracts and consumer protection law. And I'd like to ask two basic questions in this context. First, what are the regulatory tools that consumer protection law uses? And use some kind of economic thinking to conceptualize the field, to look not at the specific problems, or the specific rules, but the approaches, the techniques that we use. And secondly, to ask, more importantly, to ask, do they work? Does the legal intervention in consumer markets in order to help consumers get better outcomes, does it work? The regulatory tools, I'll give you briefly the roadmap for the lecture is, we're going to talk about default rules, about the regulation of information, both mandated disclosures and anti-deception laws, and about mandatory rules. I will explain each of these devices, what do they do, and what I mean when I say this, but this is what I plan to talk about today. And then I'm going to ask, do these things work? And if you just want to know what is the conclusion and leave the lecture, don't care about the details, here it is. I will argue that default rules are not a good regulatory technique to protect consumers, and that mandated disclosure also not an effective intervention, and that anti-deception law and mandatory rules are potentially things that work, but with very significant challenges that I will try to identify and flag to you. Okay, so let's talk about default rules and pro-consumer default rules. Can we help consumers in the market solve various problems by enacting rules, legal provisions that govern their transactions with businesses, with banks, with sellers, but as default rules, namely legal provisions that the parties can contract around? This is a very common regulatory technique in consumer law, and let me mention some examples. Most warranty law, warranties that buyers get when they buy products, are default rules. The parties can agree not to have them, either expand them or disclaim them altogether. Risk of loss allocations. What happens if something is lost during shipment? That's a default rule, and it can be favorable to consumers, but again, parties can contract around. Ownership of personal and private information. When you post content online, who owns the information? Well, there are default rules that say that the consumers own these things. The users do, but again, parties can contract around, and indeed, most platforms require users to agree to change the ownership structure. Property rights in personal context as well, similar. Choice of law. What happens when there is a dispute? At least in American law, the rules in consumer contracts is favorable to the consumer. The consumer can bring a claim in the most convenient forum. But this can be changed. And for example, consumers can be asked to agree to arbitrate and to give up the rights to participate in class actions. So to agree to something less favorable to the consumer. Why do we use default rules so prominently in the area of consumer contract law? Well, here are the reasons that I can think about. First, this is freedom of contract. Default rules are legal provisions, but they do not take over the freedom of contract. Parties, the business and the consumer, the seller and the buyer, can still agree to something different if they want. They have that freedom. It is also regarded as non-paternalistic. We protect consumers, but we don't force them to accept these protections. They can give them up, for example, for a discount. It also is thought to be good for heterogeneous environments. Different consumers might want different arrangements. They don't all want business class, they don't all want first class, and they don't all want economy class. Let them choose. Default rules mean that parties can then sort on their own. And finally, there's a political reason. Default rules are very easy to enact. The businesses usually don't object to them, even though the default rules could favor consumers, because they know that they can later opt out or disclaim the default rules. So they're easier to enact, and that is always a reason to why we see more of some kind of laws when there is less political opposition. Default rules are not only very common, they're also very popular amongst consumer advocates. There are high hopes, I call it, for default rules. The book Nudge by Thaler and Sunstein, that has inspired so many people to think about new ways to do consumer protection and has led to the establishment of nudge divisions in consumer protection agencies around the world. Well, nudge supports default rules as perhaps this is kind of as the it shows default rules as a typical nudge. It is others, prominent people have written that this is the new one-size-fits-all solution to all consumer problems. Here is, I take it from Barmul, Nathan, and Shafir. These are very influential writers in the area of consumer markets. A lawyer, an economist, and a psychologist wrote a contribution to the New York Times where they said, to avoid the next mortgage crisis, they wrote 10 years ago, why not have an opt-out home mortgage plan based, for example, on a 30-year fixed rate loan, a default rule with, some simple terms. Enact a default rule that will protect consumers. Also, people have identified this notion of sticky defaults, arguing that if we protect consumers with default rules, these default rules will stick. The businesses will not reverse them. Consumers will get what the default rule says. If it's a protective default rule, it will stick. That's the sticky default rule. And the example for the sticky default idea, the most inspiring one, is in this graph. It doesn't come from consumer protection, but it is a default rule. And this is a graph that shows what happens in different countries based on, in the area of organ donations. Do people sign up for to donate their organs in the event that they die and their organs can be harvested from their bodies to help save other lives? This is a very important area of public health. And the more people agree to participate in organ donation plans, the more organs will exist, with kidneys, livers, and other organs that are in short supply. And tens of thousands of people in the US die every year because of shortage of organs that can be resolved if we had more donors. But we can't force people to be donors. So the question is, can we get them to donate more by changing the default rule? And you see what happens across the world. There are some countries, these are the countries marked here in the yellow or golden color, where the default rule is you are not a donor. You have to affirmatively sign up and agree to be a donor in order to be regarded as a post-mortem organ donor. In those countries, Denmark, Germany, you see others, the rate of participation is very low. Most people don't sign up, don't change the default. They do not, the default says they are not donors, so they're not donors. In other countries in Europe, where the default is the opposite, it is automatic enrollment. People also don't change the default. 99% of the people and higher, 99.9 are donors. Why is it that in Denmark only 4% of the people donate, and in Sweden 85%, and in Hungary 99%? The difference is due to the default. One way or another, people stick with the default. If they stick with the default, then we can enact default rules all around consumer protection, and people will stick with the default. That's the logic in nudge, in one-size-fits-all kind of ideas. And then we see this indeed arise, these proposals, in many contexts. So I mentioned the proposal to solve the mortgage crisis by enacting a default, a plain vanilla pro-consumer 30-year fixed rate, or in homeowners insurance in places where there are floods, to have a default coverage for floods. In employment law in America, change the default rule so that people can be fired only for good cause. In the privacy area, to have a default rule that says that businesses cannot collect your personal data unless they get you to disclaim the default. In consumer banking, all sorts of services that are very expensive for consumers are thought to be, let's say, rule them out by default, so that if consumers want, they can opt in. The hope in all these areas is that these provisions will stick, and consumers will get the benefit of pro-consumer arrangements without being forced into it. It was offered only as a default. There is a problem in this area, and all so far so good, but there is a problem. The problem is that people do opt out, that it is incredibly easy for the businesses to guide consumers to reverse the default. Usually all it takes is one click, I agree, and you've given up all of these wonderful protections that lawmakers have enacted. Namely, defaults don't stick. The examples of sticky defaults are few and far between. Most defaults don't stick. I'll give you an example. Already in maybe 75 years ago, if not 100 years ago, sales law in the US and around the world began to change, and the law provided buyers who buy goods with very generous warranties. The goods have to be of good quality, they have to be merchantable, they have to be of acceptable quality. Can't sell people shabby goods. This is an implied warranty written into the law. But here's what happens. You just click to this every time you buy something. And if I zoom in to one of the important paragraphs, to the full extent permissible by applicable law, Walmart.com disclaims all warranties, express or implied, including but not limited to the implied warranty of merchantability. So it took an enormous regulatory effort to enact a pro-buyer default rule, and poof, it was gone. Every time you buy something on Walmart.com, on Amazon.com, you agree to disclaim the default. This is entirely standard now in all sales, the disclaimer of warranties. Similarly, the limitation on damages. Here's another provision where a default rule that is pro-buyer and not entitles the buyer to damages if they are injured by a product says Walmart, under no circumstances shall Walmart be liable to you or to any other person for any indirect, special, incidental, or consequential losses or damages. Poof, another default rule is gone. How easy it was. All you had to do is click. Sometimes not even click, it's just a sign when you enter the store. So there are very few cases of sticky defaults. Default rules are too weak. Why was it working in the organ donation case? Because in the organ donation case, there is no big business, a bank, a seller, an internet platform that wants the consumers to opt out. So there is a default. Nobody is kind of leading the consumers, asking them to opt out. So the consumers stick with the default, the organ donation. Most of them don't even know. When we have another sophisticated party on the other side of the transaction, a party who doesn't want the provision that is favorable to the consumer, that party will write a contract that disclaims the default rule, the protection, and will invite the consumers to click I agree, and will even tell the consumer, you actually can't buy from us if you don't click I agree. And there it goes. The sticky default was not so sticky after all. Default rules, I conclude, are too weak to protect consumers. They have not worked in the past, and they are not going to work. And if we think of it as a one-size-fits-all, a one-size conclusion, it's not that they solve the problem and will solve the next mortgage crisis. It's that they will never solve any problem and never prevent any future crisis. That is my view about default rules. Okay, that was the first regulatory technique I wanted to pay attention to. Now let's talk about another possible way to protect consumers, and that is through the regulation of information. This is a major problem in all of law, not just in consumer protection law. Parties to transactions have asymmetric information. On the one side, we have a sophisticated party. Maybe it's a seller or a business, a firm or a hospital or the government or a sophisticated advisor. And on the other side, there are, well, people. It's not sophisticated, not informed, not specialists, and they have to deal with the sophisticated, larger entity. The problem is that without good information, people make poor decisions, and the sophisticated party may take advantage of them. That's the problem in consumer protection, that's the problem in internet regulation, in patient protection, in buyer protection, in employment law, in insurance law. In every one of these areas, we have problem of asymmetric information and the concern for exploitation. If the problem is information, then we know what the solution is, right? If we identify the source of the unfairness to be a lack of information, then we have identified the direction for solution. The solution would be require the firms to present accurate information to people. That is the regulation of information. And that is what, once 100 years ago was said by a famous American jurist, Justice Louis Brandeis: sunshine is the best of disinfectants. Sunshine, information, shining the light will solve the problems. You don't need more aggressive interventions if you just give people information. Now, there are two branches to information regulation. One is the regulation of voluntary disclosures, of when firms give consumers information voluntarily, namely they are just offering some information, it has to be truthful. That mostly applies to advertising. Advertising is not mandatory. Firms can advertise if they want or not, but if they say something, it cannot be deceptive. No fraud, no deception, truth in advertising. There are also some problems, and I'll mention them, not of deception, but of manipulation of consumers. Separately, there is the regulation of mandated disclosures, an obligation, affirmative obligations to provide information prior to the transaction. Duties to warn, for example, or labeling of products. These are requirements that firms must abide by so that consumers will have better information. Let's talk briefly about the first of these information devices, the regulation of voluntary disclosure or voluntary messages. As I said, it's mostly false advertising law, anti-deception law. It is, in the US, it arises mostly by lawsuits that are brought by the government agencies against companies, or one competitor sues another for false advertising, but also we have consumer lawsuits. The economic logic of this is obvious. It would reduce search costs. If a consumer hears a message and they know that there are sanctions for lying, then they will believe it. And they won't have to look for verifications of the message, of the information. They will be more able to trust it. That reduces the cost of searching. Sellers, in that sense, who have the information, should just avoid the confusion that might otherwise arise. Beyond that, it allows consumers to distinguish different products. If the information is correct, then people make better consumption decisions. Some of us look for one product, others look for another, one quality versus another quality, and you can believe what the firms say and buy the things that you want. And this would also translate into productive efficiency, where better incentives to produce high quality products will arise, because If you produce a high quality product, you tell the market what the value, what the attributes are, and someone who produces low quality product cannot imitate you, cannot say the same thing about their product, because otherwise they will be committing deception or fraud, and they will be punished. Separately, in this area of regulation of voluntary disclosure, we have problems of manipulation, where there's no lying, no deception, no fraud, but giving consumers only part of the information, only good information, not the bad information, or taking advantage of consumers' misperceptions and short memory and myopia and other forms of irrationality to feed them messages that are correct, but that are known or intended to cause consumers to make bad choices. Presenting, for example, choices in misleading ways, so that consumers who want to choose one thing will not notice that they're choosing another thing. Selling all sorts of add-ons that consumers can unclick, can disclaim, but it's very hard to see that these things are added. And that is another form of manipulation, or nudging consumers to make bad choices. There are now names for these forms of manipulations: dark patterns or sludges. The idea here is we have a problem. These are things that are not very difficult to solve, these manipulation problems from a regulatory perspective. And I'm sure that every regulatory agency, consumer protection agency around the world, is wrestling with how to address the problems of manipulation. They already know what to do about deception. When firms lie, you know what to do about that. We have remedies for that. But what to do when firms manipulate, when they don't lie? They just tell partial truths and kind of find ways to get consumers to do things that consumers don't want to do. Look, much of advertising is manipulative. We can't say that manipulation is illegal because we will rule out all of advertising. We have to identify what exactly is the problem. And we can ask, for example, could prices be manipulative? When you set up a price, could that signal information that is manipulative? I'll give you an example, a very interesting, a very difficult case. Look at these two products sold by Walmart stores under their generic brand Equate, the Walmart store. One is called, on the right-hand side, the green box, headache relief, and is sold for less than $3. On the left-hand side, in the red box, is migraine relief, and is sold for $9. Now, the only thing is that inside the box are exactly the same product. The chemical components of the pills is the same. They are designed to look differently and priced differently, and there's nothing wrong about it. Migraine relief is, you're allowed to call this product migraine relief and headache relief, but by calling it migraine relief, there is an implication that this is a more sophisticated and advanced medication, and indeed it costs 3 times as much. So there was a lawsuit. Is this manipulation? The court said prices cannot be manipulative, but do we agree with that? Separately, it does. What the problem. Another problem here is that manipulation is not deception. So we have to to invent new tools to resolve it. I'll give you an example, in an issue that I care a lot about: genetically modified crops. Look at this packaging of Tropicana orange juice. There is a little label that I highlighted in this orange circle in the middle. It says non-GMO. Namely, this juice is made from plants and ingredients that have not been genetically modified. But there are no GMO oranges. They don't exist. So in that sense, it doesn't tell you any information when you buy orange juice, non-GMO. Does not distinguish it from yes GMO orange juice. That seems to me quite manipulative. Even more annoying, so to speak, is this salt product, pink salt for people who like to spend $10 on salting their food. Well, you get some kind of Himalaya pink salt grains, and it too has a little non-GMO label. Now, salt is a mineral. It has no genes, so it cannot be genetically modified. It's another way to prey on consumers' misperceptions without misleading them. So it's not exactly deception, but I would think of it as manipulation, and maybe consumer protection law can have something to say about that. So that was the regulation of voluntary disclosures, things that firms say to try to kind of jazz up their otherwise mediocre products, to make them look better, and that are not always correct or that cause people to make bad decisions. Separately, there is the very big area of consumer protection law that is mandated disclosure of information. I wrote a book about that, so I'm going to tell you the gist of what my thoughts are about mandated disclosure. This is the regulatory technique where we require the informed party to actually give information to the uninformed party. All sorts of warnings, labels, disclosures, and so on. It's everywhere. I think it is the most common regulatory technique in all of law. In every area of the law, we use disclosure in financial protection, and just in the consumer context, financial protection. When we invest money or borrow money, we get disclosures. When we buy real estate, product warnings in tort law is a form of mandated disclosure. Privacy protection is largely about disclosure, telling people in a very clear way what is being done with their personal data. It is kind of to allow active choice by consumers. Food labeling, how to help people make better food choices. Well, label the food. It's a form of disclosure. Advertising disclaimers. If the advertising is misleading, well, you have to make a disclosure so that consumers will not be misled. Informed consent in healthcare. Conflicts of interest disclosures is another example. When consumers go to brokers, doctors, lawyers, accountants to get professional advice, what happens if the advisor is conflicted, is receiving all sorts of kickbacks from other parties and give advice that is biased by it? Well, the solution in the US and in many other places is to require disclosure. Tell your advisee, your client, that you have a conflict. That will help them protect themselves. So you see, disclosure, again, high hopes for disclosure. Why it is mandated so often? It's very sensible. Remember, we said that the problem is thought to be a problem of information. People make bad choices because they have poor information. If we know what the problem is, then the solution seems very sensible to give them information. It is uncontroversial. Both Republicans and Democrats like it. Right-wing and left-wing like it. Consumer progressives and libertarians agree that disclosure is a sensible form. So there is never any politician that votes against disclosure. These laws pass unanimously. It is feasible. Disclosure does not require budgets for the government. You just enact a mandate on firm that is usually fairly cheap to comply with. It is riskless. There's no downside to giving more information. It's thought to be harmless. And it is also irrefutable. When it doesn't work, which is often the case, always the case, there are always new ideas on how to fix it. So it's you never give up on the paradigm, only try to change the way it is being done. That's why it is mandated so often, but it is also fails so often. And in the book that I wrote about it, I tried to document the failure of disclosure, and both empirically and logically. I won't give you too many examples empirically of the failure, but basically it is very unsuccessful. People don't change. The problems are not solved by the disclosures. Why? Well, one thing has to do with literacy and numeracy. People are just not sufficiently literate in all these areas where they get disclosures. And I'm talking about people like you, the audience here, and me, a professor in this area. We cannot master every technical area, every technical field. Look, for example, let's talk about financial disclosures. To choose a mortgage, according to the American Central Bank, the Federal Reserve, to choose a mortgage, people need to understand indexes, margins, discounts, caps on rates and payments, negative amortization, payment options, and most importantly, what might happen to your monthly mortgage payment in relation to your future ability to afford higher payment. I have to say, I'm not sure I even understand the words. I definitely don't fully understand the concepts, and I don't know how to wrap my mind around all of these things in order to choose a mortgage. And I teach mortgage law at the University of Chicago. It's very hard to be an expert on everything. It's very hard to be an expert on mortgages when you only take once or twice in your life. By the time you figure out the mistakes you did, it's too late. So what would all the information do to you? Why would it be helpful? That's the problem of literacy that I talked about. Separately, there's a problem of overload. You know what disclosures look like, and if you don't, here is an example. I've shown this picture to some of you in the past. This is a scroll that I made from the Apple terms and conditions when I had to accept them to install an update on my device. You know, update 13.0.7 or whatever it is. They said, email it to myself. I printed it out, and it was 10 meters long, 30 feet long, of 8-point font. And it is so unbelievably useless. Nobody can read it. I don't think that the lawyers that wrote it read it, because I found typos in it, spelling errors. But I hung it from the ceiling of the University of Chicago Library for everyone to see. This is an example of overload. How could you become informed by looking at something like this? Separately, there is what I call the accumulation problem. We just get disclosures all the time, here and there, and every day you are exposed without noticing to dozens of disclosures. You've trained yourself not to notice them, to close boxes that open disclosures to you, and to not look at labels and so forth. But just to give you an example, when I took a mortgage a few years ago, I received 50 disclosures, exactly 50. So I wrote them down for you to see. Each one is mandated by a different law to make sure that I don't make mistakes. Some are about insurance, and some are about privacy, and some are about right to return, and some are about taxes, and some are about revocability and appraisal, and blah, blah, blah. You know, I don't know. I don't think that I've read a single one of them. How could a consumer understand all the accumulated disclosures? And that's just one transaction. Also, disclosures fail because people don't like to make the decisions in the way lawmakers think they ought to. Namely, look at all the information, weigh all the risks, and make a very responsible decision. It's not fun. It's both rational and irrational to behave this way. It is rational because most of the disclosures deal with small things. Why waste so much time? There is opportunity cost. Also, what if I say no to it? If I don't want it, then I'll have to pay more, or have to go to another business or open a new bank account. What a headache. So I'm not going to bother reading. There's also an emotional aversion. Disclosures are not fun. They're not a suspense story. They're not comedy. They're not Romeo and Juliet. Not that this is fun, but at least it's captivating. They are agonizing. So who wants to read agonizing literature? That's the decision aversion. And finally, there are behavioral biases. even if people were to read, and even if people were to understand the information and try to make a rational decision, humans make a lot of mistakes when they deal with uncertainty and with complicated matters. They use, we know from social psychology and cognitive studies that people use information poorly, very often in many different ways that are hard to predict sometimes. Conflicts of interest disclosure is an area where we have fascinating data, experimental data, that shows that when consumers are told by an advisor, look, you have to know I have a conflict, so I have to disclose my conflict to you, and here I'm disclosing it. What happens is that consumers trust the advisor more rather than less. And that is kind of an unintended consequence of the disclosure law. In short, disclosure fails, and the failure is due to complexity. Complexity of the decision, underlying problem you have to decide. Mortgages are complex, medical treatments are complex. To just give you information makes the disclosure complex. But even if the disclosure were not complex, the underlying problem is complex, and it's very hard to make good decision. And just shoving information, paperwork in front of consumers is not usually a very effective aspect. There are so many anecdotes about this that I can tell you. I've seen, but I've noticed, for example, that when I go to the pharmacy or to the clinic and sign in for a treatment or to get a medication, it comes with paperwork, informed consent or disclosure or warning of some kind. And I've also noticed that right near the counter when I get this at the pharmacy or at the clinic, there's a big recycling bin where I can conveniently throw the disclosure into. And when I look at those recycling bins, they are full of this disclosures that people are throwing. So what is the clinic doing? What is the pharmacy doing? They're giving us the disclosures because the law requires it, but they already know what we're going to do with it. Can mandated disclosure be fixed? Is there a way out of this catch? So many problems are solved with disclosures, but disclosures don't work. What do we do? Well, most consumer advocates believe in disclosures, and therefore they say, let's not abandon the regulatory approach. Let's still use disclosures as the solution, but let's do it better. Let's fix them so that they work. Well, sometimes they don't work because of, we said, literacy. People just don't understand these things. It's too complex. The solution, therefore, is education. And I cannot tell you how often I've seen these proposals to educate consumers. The problem is that we see it. Here's an example of areas where people have written and advocated for more education. Financial literacy education, investment and loan-taking education, healthcare education, insurance education, privacy education, safety education, environmental education, nutrition and eating habits education, procedural legal rights education. What's going on here? This is a law and a proposal to basically wash us with education of things we don't want to know. These are not the things people want to be educated about, and therefore the result of these proposals will just lead to either more accumulation problem, so much education that becomes no education, or this kind of result, not very motivated clientele, or this kind of result, protest. But one way or another, it's not going to work. You cannot educate people in everything in a sophisticated society. So maybe we have a different solution, not education, but simplification. This is the new popular solution. So many smart people are now advocating for simplified disclosure. Cass Sunstein wrote a book titled Simpler. And a number of proposals that have proliferated in the literature and among lawmakers and consumer protection agencies on how to do simple disclosures is, unimaginable large number. That too doesn't work, unfortunately. It's, by the way, simplification is not a new idea. It has been being proposed now. I've been following literature that shows that lawmakers are trying to simplify disclosures for over 50 years. They are now in the next stage of trying to simplify using behavioral insights, but they've done that already before, and it has not yet worked. There's nothing to show for. I want to show you just one example of failure, although there's enormous amount of literature that I can expose. Some of it I contributed to. This is a great study from Mexico, published in a top econ journal a few years ago. It was an experimental study, but with real people, not in the lab. Credit card disclosure nudges. Can you get people to behave more rationally and more safely in the use of credit cards? So this was a large-scale random assignment experiment. It was done with the cooperation of a major bank, and it included 160,000 subjects that got different treatments, real people with real credit cards, with real problems of unpaid balances, and they were getting disclosures and warnings and prompts and nudges to try to get them to behave in a smarter way. And different people got different treatments, so we could do a comparison. The goal was to induce high debt borrowers to switch to cheaper options available to them. So here is one simplification, interest rate message that people got. Just telling them, what is the interest rate? It's a large highlighted number so that they will be, oh my God, look at how I'm paying, how much I'm paying. Another one was this months to pay message. If you only pay the minimum balance, it will take so many months to pay the existing balance. That's another scary thing that might prompt people to pay more. A third is what they call the peer group message, letting people know that they are paying higher, that their debt is higher than average debt for people like them. So that you know, oh, something is wrong here, I need to do something about it. Then a warning message. Don't get confident. Paying off a debt is not that easy. Don't let that happen to you. And finally, kind of a relative risk thermometer, showing people in a way that's really simple, from green to red along the scale, where they are. And hopefully those that are seeing themselves in the red will take more steps. These are the examples of the interventions, the very simple disclosures and warnings. Again, there are high hopes in this area because if it were work anywhere, it will work here. The treatments were sent to people with high debt who were paying a large fraction of their income as interest. They should be motivated to solve that problem, not to keep paying finance charges. Surveys done before the experiment among these people showed that they were unaware of their interest rate and that they were overconfident of their ability to pay the debt. So they're already mistaken. They have an information problem. That means that this is an area where you can try to fix their information problem. And finally, and very importantly, the high hopes had to do with the fact that people could do something about it. They could find cheaper options. They don't have to carry a balance on the credit card. That's the most expensive way to borrow. It is easy to switch, for example, by transferring balances. So there's something they could do. Nevertheless, there were disappointing results. In fact, there were crushing results. None of the nudges reduced the level of debt. I should say it again. None reduced the level of debt at all, not even a little. They didn't work. None of the disclosures reduced the level of delinquency, namely reaching a point where you are, violating your no more paying and a delinquent. None of the nudges led to any account switching, to more account switching, to solving the problem in the rational way. The months to pay nudge that I showed, the second intervention, actually increased the rates of default rather than reducing it. And the peer comparison nudge, telling people you're in the higher risk, overall cause people to pay less than of their debt rather than more. Overall, the authors of the Mexican study concluded that all treatments have zero or tiny effects in all outcomes measured. This zero effect, empirically, is precise and robust across subsamples. That means it's not because we don't have enough data. It's not due to the lack of statistical power. It is an actual zero. And where we saw some non-zero effects, they were relatively small and short-lived, lasting only 1 or 2 months. How demoralizing. I have to take a glass of water after I read this. Every time it upsets me anew. So remember we said, can mandator's disclosure be saved? Education doesn't work. Simplification, no evidence that it works. Oh, nutrition labels. Why am I saying nutrition labels? Because every time I used to give this talk about my book on the failure of disclosures, someone raised their hand and said, but we use nutrition labels on food. They work. Why can't we do it this way? This kind of label on food, I use it. Many of you use something similar, either if you have exactly this or something similar in your countries, but this is very useful. In general, calorie labeling is very useful. When I stood at Starbucks and took this photo before ordering the lemon loaf and seeing that, true, it's only $1.85, but it is 440 calories, deciding not to buy it then, that helped me. So that seems to work. And this is a proposal that I saw in England, in Britain, in the UK, for energy equivalent label. It's not something that is enacted, but it is proposed. How many minutes do you have to work out to burn the calories of this soft drink? Maybe that's a kind of a nutrition label that is very simple. And again, we have big hopes here. In the US, when she was the first lady, Michelle Obama, that was one of her issues of getting people to eat better, and partly by improving the labels. She said, the nutrition label will make a big difference for families all across this country and will help solve the problem of child obesity. These hopes are also very sensible hopes. People are motivated to eat well. We all try to eat well all the time. We need better information because most of the food that we eat is processed, so we don't know exactly what's in it. It's a problem of information. And the labels are simple and noticeable. So it would work, right? Again, wrong. Despite your sense that it works for you, many of us, it doesn't really change much. In fact, studies have dispelled the notion that these things work. A study of studies, review of the literature shows that they do not have the desired effect in reducing overall calories. The calorie labeling did not change the number of calories that people eat. That's the ultimate goal. And it failed. Yes, you may have put a particular lemon loaf or cookie back on the shelf, but you ended up, not being that honest with yourself later. In another study found out that, for example, people are eating no less and sometimes even a little bit more. And that the effect is particularly pronounced amongst lower income and lower education populations, where usually the obesity problem is more prevalent. Do you really think that this is a problem of information? I want to challenge the idea that nutrition labels are needed to solve a problem of information. People don't eat well, and maybe they need information to help them, but ultimately it's much more than information. It's the cost of food, it's the willpower that we have, maybe other things. I'm not an expert in this area, but I don't think it's a problem of information. It's also a problem that because, yes, if we get labels and eat less calories, we become hungrier. So we eat more often. And here's a study that shows how things changed in the US in terms of the number of minutes between meals. We used to have, if you look on the right-hand side for adults, 271 minutes between eating occasions, between meals, and that was reduced, and that translates to the number of meals a day that has risen, and this is for the different percentiles and different groups, but if you focus just on this, for an average American, from over one generation, the number of eating occasions has increased from 3.5 meals a day to 5 meals a day, 5 eating occasions. So yes, the label helped us eat less every time we eat, but it didn't help us solve the underlying problem of being hungry. All of this is in the book that I mentioned to you. It's titled More Than You Wanted to Know, The Failure of Mandated Disclosure, written with Carl Schneider and published 5 years ago. That's why I think that mandated disclosure works. So we've talked about 3 regulatory techniques so far: default rules, anti-deception regulation, and anti-manipulation, and mandated disclosure. And now I've suggested to you, that in my view, 2 of these, the most common techniques, don't work. Anti-deception does work, but it has to find ways to evolve and solve the problem of manipulation. Now let's talk about the big, intervention, the most powerful intervention, and that is mandatory rules. Mandatory consumer protections, things that consumers cannot disclaim, that the businesses must abide by. So these are pro-consumer arrangement that cannot be contracted away, like minimum quality in rental housing, the implied warranty of habitability, mandatory warranties like lemon laws for the purchase of cars, rights to withdraw from transactions. They are very popular now all over the world to give consumers 7 or 14 days to withdraw from various kinds of protections, not as a default rule, as a mandatory rule. It must be attached to the transaction. Maximum rates of interest, usury laws, that is a mandatory rule. Prohibitions on unfair terms, blacklists are mandatory terms. For example, in the US, we had the whole issue of non-disparagement clauses. Businesses that required consumers to agree that they will not write a negative review on the product or on the business. That is now subject to a mandatory prohibition. You are not allowed to require consumers to do that. These can work. Absolutely, they can change the outcomes, and sometimes for the good, and I'll give you a hopeful, I want to kind of mention here something hopeful. Most of my talk today was about things that don't work, so here's an example of something that works. Mandatory protections in credit card contracts. I chose that because just 5 minutes ago, I talked about the Mexican study about nudges and disclosures in credit card contracts. Doesn't work. So maybe we do have to do something stronger, more powerful. And indeed, there is reasons to do it. This was reformed with mandatory rules in the US in 2009. Before the reform, there was a problem. High penalties for late payments. People had to pay these high finance charges. Interest rates could increase for outstanding balances. Teaser rates. Get people to sign up for very low rate, 0 rate or 1% for an introductory period, but for a very short period. And then they skyrocket. And that turns out to hurt especially weak consumers. I'm going to show you a few empirical charts that demonstrate that the problem in this consumer market was concentrated amongst the weakest of consumers. So what you see along the horizontal scale is the FICO score of consumers in America. Low FICO score, low credit rating means you are a relatively low income or low income consumer that has hard time paying your debts, you get low rating. At the high end are the most affluent consumers that always pay their debts. So look at the share of who makes full payment every month on their balance. People on the right-hand side, namely those with high credit rating, they pay every month almost all of their balance. Whereas on the low half of the chart, people pay only 10% of their monthly balance. The share of the account that is paid of the outstanding balance that is paid is only 10%. So these are the people that are going to accumulate finance charges, and they are the less affluent ones. Who makes minimum payments or less? It's not a good idea to make minimum payment because that means you're borrowing money from your credit card company. That's the most expensive way to borrow money. Who does that? Again, it's people with low FICO scores, low credit rating. They are the ones who are subject to these grueling charges. Who pays finance charges? Who is late? Finance charges are charges when you are late. Again, you see that on concentrated in the low credit rating, in the less affluent part, in the poorer part of society. Who pays fees? Same stories. And finally, another couple of things. Who are the ones that are the default, that are delinquent, where the credit companies have to charge it off, say, this is a debt we will not be able to recover. Again, it is in the low range. That is, they eventually succumb and collapse under the weight of the debt and don't pay off and maybe go into personal bankruptcy. The banks, the credit card companies, make profit mostly, almost entirely, from the lower part of the market. Poor people end up subsidizing the credit card perks and the frequent flyer miles that the middle income people enjoy. Higher income people, the highest income people with the highest credit scores, are a small source of revenue, and this has to do mostly with swipe fees and things like this. They buy so much and such expensive things. They pay for first-class tickets from Rio to Chicago, $15,000 with their credit card, so the credit card companies are making money there. Okay, so this is a problem. An incredibly unfair burden on the weakest part of the population. So the reform used mandatory rules. No increase of interest on outstanding balance. Teaser rates have to last for at least 1 year. No unreasonable limits on the penalties for late payment. These are not particularly controversial things. These are things that seem fairly moderate, but they are now mandatory. All credit card contracts have to include them, and also a few new disclosures. We'll talk about that in a minute. The banks fought this tooth and nail. They said this is going to be a disaster for the market. They said that the rules will backfire, will hurt more the people they are supposed to help. They said that there will be a price effect, that they will have to charge higher interest rates and higher annual fees because they are no longer able to get income in those other ways. They said that they will exit the market in some places, namely will not offer credit cards to poorer people, people with lower credit rating. And that was a big concern. In fact, I remember that reform, and I remember reading this, and I remember nodding to myself and maybe speaking with colleagues during lunch and saying, wow, this is really going to backfire. We're going to have this credit card protections, and it will end up hurting more than helping. Not good. Well, was I wrong, and were the banks wrong? Yes, this is what actually happened. Look at the line, the upper line, and what happens after 2010 when the reform was enacted. The upper line is the fees, the total fees paid by the people with the lowest credit rating. Their fees dropped sharply. Instead of paying almost 25% of their outstanding balance as fees every month, they now pay closer to 10%. There was also some drop for the next weakest group of consumers, also low credit rating, but not the lowest. And then for everybody else, no change. People, middle class and upper middle class and upper class account holders, they did not suffer any change because they had no problem to begin with. Look what happens to interest rates. The bank said interest rates will increase. Nothing increased. If anything, they look like they're going down. Look what happened to new accounts. The bank said that we will not give credit cards to people, especially not to those with lower credit ratings. Well, again, that solid line is the people with the lowest credit rating, and they got much more than they did prior to the thing. If anything can be seen in this picture, is that none of the problems the banks identified and warned us against materialized. The key findings in a very important study that was published by Agarwal et al. 5 years ago based on this data is that the new credit card mandatory law limited some important charge fees. These fees declined significantly, especially for low-income consumers. The mandatory rule saved consumers, especially the low income, $20 billion per year. That's a very big effect. And it did not have any of the unintended consequences. It's like win, win, win. And so we have more, not less accounts, no increase in the interest rates. This is a successful intervention that helped low-income borrowers who otherwise made irrational borrowing. And that's a good... That said, if there was, and just as a footnote, the same reform also required that credit cards will have a new, better disclosure, a nudge. This is what is highlighted here. It's again months to pay nudge, telling you how long will it take you to pay and how much money will you pay if you only pay the minimum balance every month. That didn't make any difference. That's what it looks like. They found in the same study that saved people not $70, $70 million every year. Remember, the mandatory intervention saved them $20 billion a year. The disclosure changed behavior, $70 million. $70 million, I want to say, in the credit card market is a rounding error. It's less than the printing cost of these statements with the nudge. It's basically nothing. So mandatory rule helped here, but let's not be too excited about this reform. There are often many unintended effects of mandatory rules. And we have to make sure that when we enact one, that we go into areas where we can check for their existence and maybe roll back interventions that have these unintended effects. For example, they could raise prices sometimes. Here, this is what the banks warned, and maybe it did not happen in this case because the banks were able to earn in the credit card markets some super profits, extra rents, and they just lost some of these extra profits. But in other competitive markets, there could be increase in prices if, for example, airline regulation would require airlines to give more space, more room, legroom, and to forbid some of the discount airlines from cramming people in like sardines. That will raise prices. Not sure that would be the best intervention. In that case, it would also, mandatory rule could also shrink markets, and we know that usury laws sometimes limit the ability of people to borrow and force some consumers to exit. We have to ask ourselves whether this is an acceptable result. And finally, and sometimes less visible and known, there are regressive effects. Sometimes mandatory rules help most those who need help least. The benefits accrue to more affluent consumers, sometimes at the expense of others. Think about products liability law. It's tort law, but it's a way to regulate consumer markets. It is a mandatory rule. It probably increases prices, and it provides compensation if you're injured from a product. But we know, and it is uncontested, that the compensation is higher for people with more money and richer and longer lives, namely the more affluent people. So they get the bigger benefit from this kind of insurance, but everybody pays the price. So there is a kind of a cross subsidy that works against the weaker populations. I'm flagging this in order to try to give you a balanced view of mandatory rules. They sometimes work, and we saw an example, but we always have to worry about these effects that sometimes plague other mandatory rules. And with that, I will now pause and turn it for questions and answers. Thank you.
Many thanks, Professor Omer Ben-Sahar, for this valuable lecture. Thais, our research will take the audience's questions. Please, Thais, go ahead.
Hello, Professor. Hello, everyone. We still don't have any questions, neither on Slido or in the Q&A. So I would like to say, feel free to send your questions. We still have 15 minutes, I think.
Okay. Okay, please, Omer, in this case, I guess it's better to ask you to make your final remarks, and you close this wonderful section. Thank you.
Great. Well, thank you again. I know I spoke for so long, people must be tired, and that's okay. Many of the things that I said are incredibly controversial in the sense that a lot of consumer advocates do not agree. In fact, almost everyone in the consumer protection field thinks that disclosure is a good idea. In that sense, I see myself as a maverick to try to tell lawmakers and advocates that there are better ways to go about consumer protection than the easiest ones, default rules and disclosures. And sometimes the ways to solve consumer protection problems require dangerous interventions, ones that can backfire and can have some cost. These are the mandatory rules. But if we are very serious about helping consumers in areas where there are real problems, I think that's where we need to focus. Thank you.
Please, do you have
Professor,
any questions, please?
Oh, in the meantime, we got an anonymous question. Professor, how do you think the excess regulatory can distort the prices?
Excess regulatory can distort the prices? That's the question?
Yes.
Yes. Well, one of the things that I said is that some interventions can have an effect on prices. That is, I think, in general true, although not in not necessarily in every case. We saw the example of the credit card intervention in the US, where prices were not affected. On the other hand, in the same very similar reform done with debit cards did have a price effect. And I gave the example of airline regulation. Imagine that airlines were subject to intervention that says you must treat passengers in a way that gives them some minimum quality. You must give them meals. You must allow them free check-in. You must make bags fly free, no charges for bags, and you must give a few more inches of leg space. Otherwise, it's really subhuman to fly people like that. Imagine that were the case. I don't know that is the case, but I know that some people are advocating for passengers' rights. I would imagine that that would increase prices. Now, I don't have a proof for that, but I have a strong intuition based on the fact that the cheapest airlines to fly are the ones that take away all these benefits, that put you very, very crowded, that give you no food, that sell you even a glass of water, that some places there was an attempt to charge people to go to the bathroom in the flight. But when you do all these add-ons, the basic price is very cheap. And young people that are willing to fly this way, they don't have a lot of luggage, are getting lower prices. So I see this relationship between regulation of the quality of the transaction and its ultimate price.
Okay.
I think we have a second question, Maria Lucia,
Please go ahead.
That's possible. Laura asks, do you think behavioral studies in law and economics can help enacting new laws?
I must say yes to this, because how should we not look at such important science? But I think that behavioral economics is now too often thought to be the solution. And I view behavioral economics as the problem, not the solution. What behavioral economics teaches us is that people make a lot of mistakes. Many kinds of biases, many kinds of distortions in the way they process information and make decisions. They're kind of easy to manipulate. That means that all sorts of solutions that rely on making people becoming more rational and overcoming their biases are probably not going to work. There are going to be other biases that interfere. And I gave the example of conflicts of interest disclosures. Conflict of interest is a behavioral issue. People listen to advice that is bad advice and follow it anyway. Not necessarily bad advice, biased advice, follow it anyway. So we thought, let's help them, let's de-bias them. Let's require the advisor to tell their clients, listen, I am conflicted. Well, we learned that when that happens, people trust it more. So that should suggest that the behavioral surprises that the human mind provides us are unending. And that's why I think that we want to rely on interventions or use interventions that rely less on our ability to solve the behavioral issues that afflict people's decision making.
So Gustavo asks, regarding mandatory rules, in your opinion, the experience shows that only certain markets or products are subject to dissolution, in a way that only when the regulators have a deep understanding of the market, they are able to regulate it. It might explain why some new products and technologies still challenge the regulators.
I entirely agree with that comment. It's an important one. Yes, the art of regulating through mandatory rules is the one to find conditions where it's likely to happen. If you have a super competitive market where prices are competitive and reflect costs without high return to capital for firms, without high profits, interventions requiring higher quality of service to the consumers will lead to higher prices. Do we want that to happen? Secondly, we have to always think about the redistributive effect. When we hand out some intervention to favor consumers, who among the consumers are going to enjoy it? Who will take advantage of it? Because consumers are not all alike. And if we have reason to predict that the more sophisticated, educated, affluent, wealthy, healthy, younger consumers will be the beneficiaries, and at the same time, the poorer, sicker, older consumers will not be able to benefit from it, then it's not a very promising intervention.
Okay, so Lucas asks, despite being counterfactual, do you believe that if there were consumer protection laws in the midst of the 2008 housing crisis preventing people from contracting a lot of mortgages, the outcome of mortgage defaults could have been different?
Yes, I do believe that some of the underwriting and underwriting problems in the mortgage context could have been contained, at least, with some kind of interventions, but these interventions could not be disclosures. It's not to let people have, it had to be done through mandatory rules. The most important, you know, in banking area and in the area of taking excessive risk, these are rules that regulate the market, not the transaction, like capital requirements for banks. They must have enough capital to justify the amount of loans that they're giving, and the kind of ability to pay that consumers would have that is in the transaction. So, for example, laws that came after the crisis say you cannot give a loan to a consumer who will not be able to repay it. The ability to repay is now a mandatory rule. There's a question how to verify it and what does it mean to have an ability to pay. But if we think about if we can conceptualize this standard well and require ability to repay, then we know that there will be less of these frivolous loans.
Okay, so Stephanie, she asks a more general question. She says, Professor, how do you foresee the future of a post-pandemic consumers? Or more specifically within the scope of law, will we have any changes in this perspective?
You got a little cut. How do I foresee the future of what?
Post-pandemic consumers.
Oh, well, that's a great question, and I would love to bounce the question back to the consumers amongst you, since I am barely leaving my house. Well, we know that some industries will be very much hurt in the long term, even after things go back to normal, because people will have acquired new habits. Less travel, conferences via Zoom. Well, I do hope that we will do in-person conferences in Sao Paulo and Rio. I really want to come back to Brazil and have some time with the audience and with my hosts here, Rodrigo and Maria Lucia, a good Brazilian dinner or something like this. But overall, consumers will change some of their habits, no doubt about that. And that will lead to some businesses to be understood. So markets will adjust. The question is whether consumer protection law will have to adjust to that issue aspect. Maybe there are new risks that need to be addressed. I want to make two comments on that. One, it is interesting to see how some of the protections and safeguards that were instituted in the last generations were so quickly waived in the dawn of the pandemic era. Primarily various privacy concerns. Could we do telemedicine over online? Can do other things? Experimental drugs are brought into the market with far fewer safeguards. We realize that, you know, sometimes these safeguards should not be mandatory because there are some things that are more important that need to be taken into account. So that's one thing that maybe hopefully we will think about. How much more will we continue on this trajectory of enacting more and more and more safeguards in the market? Secondly, I guarantee you that when new laws will be proposed post-pandemic, the most common type of law that will be proposed is more disclosure.
So we have an anonymous question. I think we're finished.
Excuse me. I guess we have time for only two questions, please.
Okay, perfect. So we have an anonymous question from Slido. Considering the extreme sophistication of digital platforms compared to the average uninformed users, how do we tackle manipulation issues?
That's the million-dollar question. And I think that we don't fully have a clear answer on how to generally address it because we have not yet fully articulated what is manipulation. Okay, we know it when we see it, but we can't say that all manipulation is illegal because we will basically then be saying that all advertising is illegal. Advertising is an attempt to manipulate you to show you the nice things about a particular vacation or product or service or thing without showing you the bad parts and the things that will frustrate you. But it's a, we can't have, there's no solution to that. And we definitely don't want to outlaw all of advertising. So we have to find a conceptual solution. What is manipulation? Once we know what it is, we can begin to go after it. The notion of dark patterns, which is a name that is now given for the ways that platforms and internet websites and apps are trying to make you choose things that you don't want. Maybe that needs to be outlawed in some way. But the problem in this area is that there will always be something new that will come up. We don't want to just rule out specific things. We have to find a organizing, unifying concept to tell us what is manipulation.
Okay, Thais.
Do you have time for the last question? Or?
The last question, please, yes.
Okay. So Hubanks asks, when we think about disclosure on consumer contracts, what is your opinion over general data protection regulation impact on consumerism in general?
My view here is that people differ. Consumers are not all the same. We are not all tin soldiers that have to be treated the same. Some people have very strong privacy preferences, and others have very weak ones. How many are in each group? I'm not sure, but there is at least some reason to think that the more sensitive ones are a small minority, and that most consumers don't really care. But who knows? Maybe that's different. I think it is important to try to be able to fit each population or each subgroup with rules that serve their interest. Those who want to give away their personal information so as to get more personalized environments online should be able to do that, whereas those who want to not do that should have an easy opt-out or easy way to secure that. And that's my basic approach, that we need to try to personalize the rules that apply to the collection of personal information.
Okay, thank you so much. I do hope you have enjoyed this great opportunity, and I'd like to invite you to join us again this Thursday at the same time, 3 p.m. Chicago time and 5 p.m. São Paulo real time. Once more, thank you so much, Omri. And thank you, Thais. Thank you, Rodrigo. Thank you all. You'll see you next Thursday. Thank you.